Yes, Prime Minister, good morning. There's an urgent question which is taking place right now, actually, on the advice of the Attorney General and the publication of it, and I'm going to be asking you some questions about that myself now. The Ministerial Code states that it is of paramount importance that all ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity, and that knowingly misleading Parliament leads to resignation. I asked you at the Liaison Committee on the 18th of July whether you had asked the law officers for their opinion on checkers in good time beforehand, as required by the Code and as a critical legal consideration as it sets out. You merely replied that the law officer sits around the Cabinet table and is thereby consulted, which is clearly not what the Code requires. Yet again, on Monday this week, after you had signed the withdrawal agreement, I asked you a question on your statement, how this, being a treaty, which is what this is, and only a treaty, it can be lawfully compatible with the overriding statutory express repeal of the whole of the European Communities Act 1972, and whether you had sought the legal opinion of the Attorney General on this critical legal consideration in good time before your signature. You did not reply to that question. I ask it again. Did you seek his opinion on that issue, and will you publish that advice as required by the vote on the humble address, and which is directly relevant to compliance with the Code and the full critical consideration that this legal matter clearly requires by the Attorney General before your signature and on the withdrawal agreement, and it's being laid before the House?
Sir William, you asked me this question about the fact that we had repealed in the European Union Withdrawal Act, we'd repealed the whole of the European Communities Act 1972, and that this was therefore incompatible legally with the withdrawal agreement and with the political declaration. It has always been the case that the reason we passed the European Union Withdrawal Act in relation to the bringing the European EU law, the acquis, into UK law, was to ensure that we had a working statute book when we left the European Union on the 29th of March 2019. It was always the case that alongside that, whatever the withdrawal agreement required would be legislated for in Parliament before the 29th of March 2019.
But you can't presume
so that there would be no incompatibility with these two. Well, it is up to Parliament whether it accepts that, but it was always the case, and it was always made clear that whatever was in the withdrawal agreement would be legislated for by Parliament, and that legislation obviously would take account, as it would in the implementation period, of the necessity of making putting any position into place to continue to enable the smooth function of our laws and the smooth function of that statute.
I mean, this is a very unusual situation in that this withdrawal agreement cuts across an Act of Parliament which quite clearly overrides a treaty, and that is a matter of law and a matter of fact. What I do really want you to ask the question, did you in fact seek the opinion of the Attorney General on those questions, and also in relation to the checkers questions? I'm getting no answers to these questions.
And you will know that we do not set out when we do or do not seek the opinion of the law officers, and we do not publish the full advice of the law officers. And I answered that point in earlier this week. We set out in the white paper legislating for the withdrawal agreement that the withdrawal agreement bill will make amends to the Act, to the European Union Withdrawal Act, to ensure it reflects our commitments under the withdrawal agreement. Now, obviously, Parliament has a job of scrutinising those provisions when we bring forward the bill, as it does with all legislation. But it was clear at the time, there was a recognition at the time of the interaction of the Withdrawal Act, the repeal of the European Communities Act 1972, and the legislative requirements of any future withdrawal agreement. It was set out to Parliament the process that would take place that related to those. It was very clear, and I've just set it
Well,
out
at this
again.
moment in time, the treaty is quite clearly inconsistent with the Withdrawal Act, and I don't think anyone can dispute that.
And it was, but we were always clear that what was necessary in the treaty, what was necessary in the withdrawal agreement, would be put into place with or if there were amendments necessary, they would be put into place with the withdrawal agreement bill.
Well, we don't have much more time. I simply say, I just don't think you'll get that through Parliament in the withdrawal bill when it comes up, and it's inconsistent with the existing repeal of the European Community Act 1972, which is absolutely axiomatic and absolutely fundamental to our leaving the European Union.
Well, the reason we undertook what we did in the European Union Withdrawal Act was to ensure that we did have there was no cliff edge in relation to the laws that were operating, that there was a smooth functioning of our laws and our statute book when we leave when we cease to become a member of the European Union. That was preparatory. That was important to do, preparatory work, because for any circumstances of leaving the European Union, it was important to have that in place. I think what you've just said to me is that if Parliament ratifies the withdrawal agreement, Parliament won't agree to put into place the legislative measures necessary to enact that
withdrawal agreement. What I'm really saying
agreement.
is the repeal of the European Community Act 1972 is so fundamental to this entire operation that it is quite inconceivable that under the withdrawal agreement and subsequent legislation you then modify the European Community Act 1972 and reduce the impact of the Act of Parliament that was already passed on the 26th of June with royal assent.
The circumstances in which any amendments are necessary are the circumstances in which we put into place the implementation period, which is there to ensure that there is an orderly exit from the European Union, that we have a transition through to the future relationship, that businesses are able to continue to operate as they do today, that citizens know where they stand. This is about providing reassurance to businesses and people across our country that this process will be a smooth and orderly one, and that they can have that reassurance and that confidence. I think it is entirely responsible for Parliament to recognise. We recognise that we're leaving the European Union. There is no doubt that we're leaving the European Union. The question is how we do that, and if we do that in a way that protects jobs, if we do that in a way that ensures that we're able to give people and businesses the reassurance that they need as they're going through this process.
I'm not sure that many people will be reassured at the idea that the European Community Act 1972 is going to be played around with in that way, given the fact that, as you quite rightly said, that was a decision that was taken on the referendum vote itself. But I think I have to leave it at that.
I think people will want reassurance of knowing that there is protection for their jobs, that businesses are able to, that as we leave the European Union, that there will not be the disruption that people have said would be the case if we had not had that implementation period and that transition to the future relationship.
So, William, we do have to end there. Prime Minister, thank you very much.